Today's lecture is on legal and ethical issues. Laws and ethics. Laws are rules and regulations with specific penalties set by local, state, and federal government. Ethics are social guidelines based on moral principles and values, and they are a standard of behavior based on right and wrong. The classification of laws is as follows. Criminal law is a crime against the state, the government. So a misdemeanor is a less serious crime. It's punishable by fines or imprisonment for less than 1 year. So a misdemeanor could be shoplifting $50 worth of, could be shoplifting $50 worth of merchandise. A felony, however, is a more serious crime, and it's punishable by death or greater than a year of state or federal imprisonment. A felony can be grand theft, larceny, or murder. A civil law is a crime or crimes against a person. So criminal law is crimes against the state and the laws of the state, but civil law is a crime against a person. We have intentional tort. This is assault and battery. Assault is saying bad things and battery is hitting someone. All right, so assault or battery or assault and battery. So if you're at a bar and you're bad-mouthing somebody and then you deck them, you hit them, you can be arrested for assault and battery. Defamation, slander, or libel. One is written, one is spoken. False imprisonment, fraud or abuse, fraud being more serious. Or invasion of privacy or confidentiality, like breaking HIPAA law and telling your neighbor that her husband was at the doctor's office and he's got an STD. That is an invasion of privacy. Now, unintentional tort is negligence that can be charged. So if someone doesn't take care of you the right way, that can be considered an unintentional tort. A contract is a voluntary agreement between parties. So there is agreement. There is an offer made and accepted. There is consideration, something of value. I'm going to pay $500 for this lawnmower, all right? And there is legal subject matter. Enforceable or otherwise breach of contract occurs. So the agreement is, I'm going to buy your lawnmower for $500. It's in great working order, and you sign a piece of paper that says that. Now, if you find out that parts are missing in the lawnmower, then that's a breach of contract. And then the contract violation has happened. Contractual capacity is both sides must have competency to understand the concepts and the meaning of the contract. And buying a mortgage for a house is one of the best contractual capacity examples I can offer to you. Or buying a car. Do you understand what the law is about buying a car? You're going to buy this car, you're going to pay the bank $400 a month for it. For the first 25,000 miles, they're going to do free oil change. After that, you have to pay for it. So that is understanding the concept and meaning of the contract. And you will pay for the car every month on time. You will pay your credit card every month on time. You will pay your mortgage every month on time. That is contractual law. Express contracts are clearly stated and written with all elements present, just like I just told you, credit cards, mortgages, car payments, school loans, all right? Implied contracts are conduct of parties indicates acceptance, all right? And again, an implied contract can be between you and the person who takes care of your children. An employment contract describes the duties of the employee and the employer and other considerations of employment. You sign a contract to go to work for the ABC Healthcare Company. All right, so do be sure you understand those types of law. The physician-patient contract, all right? The physician's rights are to set up practice and specialize in their chosen field and to choose a practice location. All right, that's the physician's rights. A physician is not expected to treat every patient seeking care, unless in an emergency department. You can turn someone away in your office. Restore patients to the original state of health. Again, this is making those promises you can't keep, all right? But a physician is not expected to do that. Or make correct diagnoses in every case. A physician is not expected to guarantee successful results or cures. All right, and we're going to keep going, and you're going to understand a few more things. However, the physician responsibilities are different. A physician is responsible for due care, skill, judgment, and diligence, and is responsible to keep knowledge up to date. If you're a physician, you have MEUs, medical education units, whereas as medical assistants, we have CEUs, continuing education units. And a physician is responsible to perform to the best of their ability and to educate patients regarding diagnosis, options, methods of treatment, and fees for service. Whether you can pay for it or not, you need to take care of the patient. All right? Medical assistance and liability. You recognize scope of practice for each state that you work in, and you stay within the scope of practice. In Massachusetts, medical assistants can give injections of all kinds except narcotics. In Connecticut, medical assistants can only give influenza vaccines or the flu shot. So that's a difference of scope of practice in two states. You need to understand the reasonable person standard. And if you don't understand what that is, the reasonable person standard says, what would a reasonable person do in this situation? All right. If you're walking down the street and somebody grabs their chest and falls on the ground, are you obligated because you're a board certified medical assistant to offer CPR? No, you are not, because a reasonable person wouldn't know how to do that. And we have the Good Samaritan law that protects you. If you do give CPR and the person still dies, you are not liable for their death. The Good Samaritan law takes care of you. Is a medical assistant held to higher standards inside and outside of the medical office during and outside of work hours? Yes, you are. People expect you to be professional at all times. What are the patient's rights and responsibilities with laws and ethics? The patient's responsibilities are to follow the instructions and cooperate in their care. Do what their physicians say. If you don't understand, ask for a better explanation. And to share relevant information with your practitioner. So your practitioner says, so you're 32 years old, you're seeing a new doctor, and she says, are you taking any medication? No, I'm not. All right. Do you take any herbal supplements or remedies? No, I don't. But you do from time to time. So you have not shared relevant information with your practitioner. You need to follow your orders for treatment. You need to be compliant. A couple of years ago, they came up with a non-compliant code for diagnostic coding because so many patients were non-compliant. And you need to pay for the services provided, whether you like the people or not. Whether you do and follow the orders of your treatment or not, you still need to pay for the services because you were there and taking up time and space. Patient consent. You need to give permission for examinations, tests, and treatment. And expressed consent given in words or implied consent given at the time the appointment is made. So express consent. I'm going to give you a flu shot. Is that all right with you? Yes, it is. Implied consent is given at the time the appointment is made. All right, we're going to need, you may be getting a flu shot when you come in. Will that be okay? Yes. Informed consent involves having full information prior to making decisions on a treatment plan. And the physician is the one who delivers the information, not the nurse, not the MA. And the person is not a minor under age of majority and a person who can fully understand. And it is the physician's responsibility to explain procedures and treatment plans to an adult, understanding, cognitive person. Now, what about terminating the physician-patient contract? Can it be done? Oh, yes, it can. Also called withdrawing from the case, and there's lots of reasons. If the patient refuses to follow instructions and the code that is given to the insurance company time and again is non-compliant with documentation, or the family members are disruptive, the family is constantly calling the doctor's office, complaining and getting in the way. Personality conflicts develops. We don't get along with everyone. And sometimes I'll have a physician we just don't get along with. So the physician can say, Mrs. Smith, I think you'd be better off seeing a different physician. Here's a number of physicians taking patients in your area. Or the bill remains later unpaid. They can terminate their contract with you. And if you miss appointments or cancel appointments 3 times in a row is usually the norm, then they can go ahead and terminate care with you. And how do we do this? For a legal manner, this must be followed. There needs to be a letter with reasons for the withdrawal, recommend another practitioner, and allow a grace period. It's usually 60 days. You need to send certified mail with return receipt requested to provide evidence that the letter was received at the address. You definitely make a copy of the letter with return receipt in the patient file, and you summarize actions in the patient's record. Now, the patient can terminate with no formal action. The physician has to do all of these things, but if a patient just doesn't like this doctor, they can find somebody new, contact the office, send in a medical records transfer request. I'd like to have my records transferred to, Jane Doe. But a patient doesn't need to do anything like this. The physician does. Because if a physician doesn't follow those rules, the patient can sue for liability abandonment of care. Standard of care for the medical assistant. What is your standard of care? Maintain confidentiality. Practice within the scope of training and capability. Prepare and maintain accurate medical records and use guidelines for release of information. Don't just give anybody what they want. Follow legal guidelines. If you're not sure, ask the practice manager. Don't just go ahead and do something, but if you're not sure if you're supposed to be doing it, ask the practice manager. Maintain and dispose of regulated substances according to government guidelines, and follow risk management and safety policy in the practice, and meet requirements for professional credentials. We talked about that before. What about closing a medical practice? You have to comply with HIPAA laws regarding confidentiality, and you have to inform all your patients with written communication. You have to give patient referrals or option to choose only placement practitioner with proper transfer. So you either have to give them a list of physicians, you give everyone a list, whether they choose someone on your list or not, or they choose someone or they're else, at least you've offered someone for them to go to. You have to keep all the files in a secure location for up to 7 years or more, depending on the state. And you have to share any files necessary. No HIPAA laws pertaining to closing a practice. Preventing malpractice claims. All right, these are lawsuits, and they add to the cost of healthcare, and they take a psychological toll on everyone involved. If your physician's being sued for malpractice, even if you had nothing to do with it, it still affects you in a negative manner. Risk management identifies and tracks possible issues that could come about. It develops improvement plans, and it monitors and assesses these plans and policies on a regular basis to see if any improvement can be made. What is medical negligence? Post-operative complications. We call this res ipsa loquitur, and it means the thing speaks for itself. Like abandonment, where you stop care without qualified substitute. This is a placeholder or locum tenens as a substitute. And delayed treatment. So abandonment, when you just stop taking care of the patient. All right, or delayed treatment. Well, we can't get to that treatment today. We're just going to put it off. All right, this is medical negligence. It's known as malfeasance, unlawful act or misconduct. Misfeasance, lawful act, but not done incorrectly. Excuse me. Malfeasance, misfeasance, lawful act, but done incorrectly. So they did the thing right. They followed the law, but the procedure was wrong. Nonfeasance is failure to perform an act as required, duty, or required by law. So nonfeasance, failure to perform an act as required duty or required by law. There are 4 D's of negligence, all right? Duty, derelict, direct cause, and damages. You will be asked these questions on your boards. You take your board of exam, your certification boards, they're going to ask about the 4 D's of negligence. So what is malpractice in civil law? It's based on tort law, remember, tort law, and a breach of contract. And settling malpractice suits. You can go to trial, which is a court system, which decides outcome of cases where both sides present their facts. Or you can go to arbitration, where you use a person outside the court system that decides the outcome. You can give a deposition, a sworn statement of facts. Well, please come in and tell us what happened. Or you can be subpoenaed, which is a written order by the courts to attend the trial. So we have subpoena testificandum and we have subpoena ducis tecum. Subpoena testificandum, which is a testifying, or subpoena ducis tecum, which is a written testimony. What is the law of agency? Employees are agents of the physician. All right. Respondent superior. Let the master answer. So instead of you talking about this, then your practice manager, practice owner will represent the practice. And the physician's responsible for all negligence of staff. So if this is a physician-owned private practice, the physician's responsible for whatever happens in the practice. If this is a clinic which is owned by Yale New Haven or partners or wherever, and the physician works for the company, then the company is responsible. The American Association of Medical Assistants offers medical assisting malpractice insurance through various insurance companies at reduced rates. And I don't know of anyone who's ever bought that because they're usually covered by the practice. You can look into that. Courtroom conduct. Attend proceedings as required. Appear well groomed with conservative clothing. Bring required documents if any are required. Refresh your memory before testifying. Speak slowly, clearly, and professionally, and answer all questions and only the questions asked. There are usually attorneys helping you with this, and they will guide you through this type of appearance. What about malpractice insurance? It protects physician and staff from financial loss and high cost to the practice, as high as $200,000 a year, depending on the type of practice. Necessary because of greedy, litigious society and unrealistic patient expectations. Poor rapport and communication may translate to poor quality of care. Malpractice insurance, because everybody wants to blame somebody for what happened. And honestly, everyone, sometimes things just happen. Again, malfeasance, misfeasance, nonfeasance, something which you do right but has a poor outcome. 4 C's of medical malpractice prevention: caring, communication, competence, and charting, documenting. Those are self-explanatory. Effective communication can help prevent lawsuits. Good listening skills help patients feel comfortable. Dedicated time to return patient calls. Every day, as a medical assistant, you may have the last hour of the day to return patient calls. Informed consent forms are explained and signed. You make sure they're in that patient file. Avoid statements admitting fault of physician or staff. Don't ever say, well, the physician was having a hard day. Don't go there. Use tact, good judgment, and professionalism. All right? And if it is your responsibility to explain fees before the treatment, do so. Administrative procedures and the law. Risk management. All right, this is an administrative procedure. Meeting legal standards for documentation. All right, you document everything in your life. Just start now. Document everything you do. Referrals, document missed appointments, document dismissals. Document all patient contact. You spoke on the phone for 5 minutes. Medical record corrections are automatically documented in the EHR and the EMR. Ownership of the patient record. Who owns the patient record? The practice does. Retention and storage of the patient record according to Medicare and the state, and credentialing. Remember how I said the practice manager is responsible to make sure everybody's licenses and certifications are current. The Food and Drug Administration regulatory function is part of the law here, and it requires testing on animals prior to human studies and clinical trials. We know about that. Clinical tests examine the ratio of benefits to the risks of new product. That's what we call the clinical 1, 2, and 3 human trials. Monitoring continues after approval. We will continue to monitor to see if the flu vaccine from last year was good. How is the HPV vaccine working on people? How is the hepatitis B vaccine working? And this FDA regulatory function also applies to over-the-counter and prescription drugs as well. Legal documents and the patient. We have advanced medical directive. You've all heard about this. This is the information you put down in a legal document. So if something happens to you, say you become brain dead from a massive accident and you have no brain function, and it says, if this happens to me and there is no possibility of me recovering, turn off the life support. All right, that's an advanced medical directive. If you want your organs donated after you die, that's an advanced medical directive. Durable power of attorney. You give your power of making these decisions to an attorney, not to a family member. Uniform donor card. I have one in my wallet. Patient Self-Determination Act, the PSDA, encourages discussion on end-of-life issues with family and your doctor. Advance directive required of certain facilities for Medicare and Medicaid patients. I know that most emergency rooms will ask if you have an advanced medical directive on file. Federal legislation affecting healthcare. The Healthcare Quality Improvement Act of 1986, demanded better documentation. The False Claim Act looked at false billing claims and kickbacks and self-referrals. And the self-referrals would be, I'm a general practitioner, my brother is a orthopedic surgeon, so I'm going to send all my patients to my brother. That's self-referrals. Genetic Information Non-Discrimination Act of 2008. You cannot use any genetic information, because a lot of us have DNA testing done, to deny care or coverage for insurance to anyone. Insurance carriers and employers can't use genetic information for denying insurance coverage or employment. So this new genetic testing cannot be required for employment or to obtain insurance coverage. It can't be required. Absolutely not. Its protected genetic information includes genetic test information for the individual and for the individual's family members, and information about a disease in an individual's family member. All right. Occupational Safety and Health Administration, OSHA, we talked about this before, is a division of the U.S. Department of Labor. It creates federal laws to protect healthcare workers from hazards on the job. It controls workers' exposures to infectious diseases, and it regulates exposures to toxic substances. What is the Health Insurance Portability and Accountability Act? And the purpose is threefold when this came out, all right? HIPAA, to improve efficiency and effectiveness of healthcare delivery through privacy protection, to provide access for patients to their own records while controlling inappropriate use of data, which means when you go to your doctor's office once a year, they say, will you fill this out? Who can have your information and what information can they have? Improve quality of healthcare by restoring trust among patients, healthcare professionals, and other stakeholders committed to patient care. What's a stakeholder? Other healthcare professionals and stakeholders, your pharmacist, physical therapy, all right, insurance billing people. Those are other stakeholders. Title I of HIPAA is called Healthcare Portability. It increases the worker's ability to get insurance, because before, if you had a pre-existing condition, asthma or arthritis, the insurance company could deny you. It reduces workers' probability of losing existing insurance because of pre-existing conditions, and it helps workers maintain insurance when changing jobs. Helps workers purchase insurance individually if they lose coverage from a group plan, and this is the marketplace, and it limits use of exclusions for pre-existing conditions. Keeps group plans from denying coverage or charging extra based on past or present poor health of the patient or the patient's family member. It guarantees small employers and individuals the right to purchase their own insurance, and employers and individuals can renew insurance regardless of health conditions. All that stuff was happening before HIPAA went into effect. So a lot of people didn't have health insurance. Title II is the prevention of fraud and abuse, administrative simplification, and medical liability reform. So this is the privacy rule. Patients' control over their health information. Boundaries on use and release of health data. Excuse me. Establishes safeguards for privacy, holds violators accountable, and balances public responsibility with disclosure. That last one, if it means that it's reporting communicable diseases. Measles, mumps, rubella, there was an outbreak in 2018 at Disney Resort in California. So the people that were exposed to that and did end up becoming affected with measles were reported to the public health department. Now, use and disclosure of information. The use consists of sharing, employing, applying, utilizing, examining, and analyzing information. Disclosure restricts sharing outside the entity holding the information. So, in other words, can't give your information to your husband no matter what he says. Can't give it to the insurance company. They can have records of your visits, but they can't have information they don't need. Can't give it to his police department. unless it's subpoenaed for specific reasons, all right? Managing and storing patient information privacy rules. So notify the patient of privacy rights and privacy procedures in place. Train staff to understand these privacy procedures and designate an individual to oversee the procedures. Secure patient records to limit access. Patient notification. Privacy rule requires notice of privacy practices, written in plain, simple language, and advises the patient to review carefully. Once a year, you get that clipboard. Describes use and disclosure of information, describes rights under the privacy rule, and describes a covered entity's duties. Outlines the complaint process and states privacy practices can change. That's all on that piece of paper in front of you that they ask you to sign once a year. How about sharing patient information? Core elements. Description of authorized information, persons authorized to use the information, the purpose of the requested information, patient's right to revoke authorization, and signature and date. The privacy rule allows for treatment, payment, and operations. The HIPAA security rule specifies how patient information is protected. Patient record or chart security, reception area security, patient center security, fax copier and printer security. Violations and penalties can be civil and criminal. And the administrative simplification standardized patient information. And the way they've done this is through electronic transaction records. And we use ICD-10 codes, we use CPT codes, and HCPCS or HCPCS codes for the standardization of patient information. If you go in for a sore throat, you have a J02.0 code. Everybody gets the same code. This helps to simplify billing and coding and simplify diagnoses. Everybody uses codes instead of words. What are the confidentiality issues and the mandatory disclosure? When in doubt, it's better not to release information. The patient's rights, not the physician's, is to keep information confidential. It is a patient's right to keep information confidential. Be aware of applicable laws and regulations in your area. With conflict between ethics and confidentiality, discuss the release with the patient. And written approval is needed before release of information. How many of you tried to get your medical record? Think about what you had to do to get it. All right. And that is the law part of law and ethics. We will look at the ethics portion now. What are bioethics? These are social issues. Bioethics deals with issues that arise related to medical advances. Examples: use of fetal tissue, surrogate mothers, organ donation allocation, the right to have an abortion. Legal medical practice models. There are 5 basic types of medical practice models. Please know this. Sole proprietorship, owned by 1 physician. A partnership is owned by 2 physicians. A group practice is 3 or more physicians. And professional corporation is a physician employees and clinics. Know those 5 types, please. And that is the end of today's lecture. Please go over this lecture again. That's a lot of information, and I know you will do well. Take care until the next time.